and welcome to Self-Represented in Family Court. So, dear, we discuss strategies. Yes, strategies and how to use them to get the results you want in family court. If you're self-represented, pro se, pro per, or if you have an attorney and you just need to know what it takes to get through this complex family court system we have, this is the place to be. We discuss strategy. We discuss tactics. We discuss tips and tricks. We discuss techniques. We discuss secrets. We discuss it all. Whatever it takes to get you the strategy that you need, that's it. That's here. That's what we do. So sit back, take notes, and kick ass.
Hello, it's me, Tracey Bee, and I'm back. Well, it's still Domestic Violence Awareness Month, and so I wanted to talk to you about a topic, an issue, one that is often coming up with respect to domestic violence cases in family court. So, I have a question for you. When you get those rulings from the judge, whether it be a denial, a partial denial, an objection, granting, whatever the ruling is, a ruling is a court's decision. What does it mean to you? How do you react? How do you respond? That's what I'm going to talk about today. So, anytime you go to court especially for a hearing, whether it be a hearing for a temporary order, a hearing for a final order, or sometimes you don't even know it's going to be a hearing, but a judge issues a decision, a ruling, a judgment. And so I'm going to use those terms interchangeably, although they may not necessarily mean the same thing, but I'm going to use them interchangeably for a simplicity purpose. So you go to court for that domestic violence or that order of protection, that restraining order, the DVPO, and the judge issues a ruling, whether it be, like I said, a temporary one or a final one. The judge makes a decision. The judge issues an order. The judge will say what the decision is, will reduce it to writing, put the signature on it, and you can get a copy of it from the clerk or your attorney if you have one. And you should always get a copy of every single ruling, decision, order that the judge puts their signature on. Remotely. Not knowing where to or how to is not an excuse. You need a copy. Whether you have an attorney or you're pro se, pro per, that is your obligation to have a copy of any ruling, any decisions, any court orders that the judge puts their signature on. So you get it. You got your copy, or you heard the decision, either way. And, your instant reaction is, oh my God, the judge denied my request. Or the judge granted the request, because it depends on which side you're on, how you're going to look at it. I don't mean which side of the table. I mean which side of the glass being half full or half empty. It's how you're going to look at it. But you're going to have a reaction, no doubt about it. But you know what? That reaction should be your starting point. You know what your next move should be? Yeah. Look at it, decipher it, pick it apart to figure out what your next move is going to be. So that's why I'm talking to you today about taking those rulings and using them as a source of data. Yeah, as a source of intel is what I usually call it. As a reference, as a framework, as a whatever you want to call it. It should be your starting point. It's an excellent starting point for every move you make from here on out. So let's talk about it. Every ruling reveals what the court rewards. Believe it or not, if you look at the rulings, if you listen to the judge, he or she will let you know what they are a quote-unquote fan of and what they're not a fan of. They will let you know what they find aberrant as opposed to what they find truly rewarding or worth rewarding. Look at those rulings. Read them. Pick them apart. Figure out what the judge's perspective, position, mindset was. What was their emotion? Right? You can glean it from your ruling, from your court order. And you know why I said you should get a copy? Because if you're anything like me, listening to what the judge said and expecting everything you recall to be accurate, 100% accurate, is not a smart move at all. Like when you have it in black and white, you have something tangible to refer back to give yourself time to calm down and get that nervous system regulated so that your mental, your acumen, your cognitive abilities will actually prevail and you can make sense of it. Because when you're still emotional, you're still anxious, you're still, in that fight or flight state, you're not going to be able to comprehend much. So getting a copy of that order is definitely going to get you set up for success in this specific endeavor. Look at the order. Read it with somebody. Let somebody read it with you and pick it apart. Get your imaginary magnifying glass, your legal magnifying glass, and pick it apart. Right? Because you're going to be amazed. You're going to be surprised. Right? So, yeah, they may be a win or a loss from your perspective, but it's so much more than that. Trust me. When you read those rulings, you're also going to get an idea of how the judge sees you, how the judge sees the other party. Do they find you credible? Do they find the other party more credible or more believable? You'll get an idea of how the judge sees you or views you and or the other party by looking at those rulings. There's going to be something in those rulings that gives you some idea, some indication of which side of the story the judge actually found more believable. Let me tell you about judges. Judges don't want to spend hours and hours rehashing the same issue or micromanaging or playing referee or, being the person that identifies and punishes the parent or the spouse that's doing things that are not necessarily aligned with being civil. They don't want to do that. They really don't. Judges don't, especially family court judges. They really don't want to get, to that level. They will, but they really don't. And they certainly don't want to hear you guys bicker back and forth and, giving your own account of what's true and what's not true and, becoming more and more petty with your description of the antics of the other. So they don't use their logic. They're going to use what makes sense to them, right? So you're going to get a sense of what makes sense to them or the way they think, their logic, their basis for their reasoning by reading those orders. Another thing you can glean from those orders, from those rulings, is their pattern, right? You may meet to file motions or additional petitions later on down the line, especially if it's the same judge. In some courts, in some jurisdictions, the court that handles the DVPO or the order of protection or the restraining order is the same judge that's going to hear your custody and your divorce and any other related issues. So particularly in instances like that, you get to get an idea of the behavior, the pattern that the judges will exhibit. Because, say for example, you file several motions because the other party has been just completely violating any sort of temporary orders or agreement. You file contempt, the contempt after contempt. But when the other party files their motion, and they might have filed a contempt here or there, modifications, enforcement, you will get to see what the judge typically does as a result of you making the decision to file contempt after contempt versus the other party filing different motion. You get to see whether the judge think it's cool that you are emotional in your motions for contempt. And that's the motivating factor, as opposed to the other party being more strategic and filing other motion other than contempt and using more fact-based law and procedure in their motion. You'll get to see the judge's patterned behavior. Are they more inclined to table your motion, your contempt motion? Are they more inclined to grant the other party a continuance? Are they more inclined to put your motion on at the bottom of the list or the court agenda for the day or the month or for the hearing? You'll get to see how your judge typically handles specific issues, specific procedural things that you might employ. And it's really important for you to know, especially because the judge is not going to be, most judges anyway, are not going to be that understanding when you're filing contempt after contempt because you are emotional. And, I get it. I get it when you are a survivor and you've dealt with, coercive control and manipulation and gaslighting and physical abuse and emotional abuse and mental abuse. You might be at that stage, at that heightened stage where you are emotional and you are unable to regulate those emotions. I get it. But when you are going to court, you need to understand that the judge, and some judges are trained, believe it or not. I know a lot of you think they're not, but a lot of judges are trained. They are trained in TV and, coercive control, and they're trained. But when they're in the courtroom, it's completely different for a lot of them because of the time constraint, of the overload, of the need to act apathetic or to lack empathy because of the position it might put them in. Whatever the reasoning, you going to court violent contempt because you're acting out of emotion and expecting the judge to, be amenable, be empathetic, be understanding. I wouldn't. So it's important for you, though, if you're not convinced by me telling you that, it's to evidence those rulings. Look at those rulings. Notice the pattern. Identify those patterns so that you'll be able to, to spot them yourself. You'll be able to see. You'll be able to confirm or not the validity of what I'm saying. Because this is your case. You may not get another chance, right? You may not. Especially when you're self-represented. It's incredibly important. Even when you have an attorney, though. Even when you have an attorney and you get those rulings, let them go over them with you. Make an appointment, set up a meeting. Yeah, it's worth the $350 for the hour meeting or $500, whatever it is. It's worth it to actually go over the ruling and let them explain to you. Let them highlight the things in those rulings that I'm talking about. Those patterns, those preferences, those, even the flaw, the predictive behavior, the language they use, the judge's preferences. Let them explain it to you. Let them do it together as a strategic move. You're not doing it just because you want to know. You're doing it so that you can be 10 steps ahead. Because again, you're in court that you're not, believe it or not, your soon-to-be ex, or your ex is not your enemy. Is not the only enemy, should I say. You have to concern yourself with the court itself, the process, the key players. That means the judge, the guardian ad litem, the forensics, you name it. You have to be concerned with them as well as especially the judge. Especially the judge, because it doesn't matter what your soon-to-be ex or what your ex, their position is, what their claims are, what the defenses are. It's still going to be, if you're in family court, I'm not talking about if you're going to mediation and you're going to resolve it without court. I'm talking about when you're in court. Most of what I discuss has to do with the family court process itself. That is what I do. That is my specialty, the family court system, the process itself. It's not just family law, it's family court. There is a difference. And so family court, the process, the system, a huge, huge part of it is the judge. So now you've gotten all this information. Now you've looked at your order. You looked at language. You looked at if the judge said things like, both parties must cooperate, or this is a high conflict case, or there's communication issues on both sides. You now need to know, you need to think to yourself, wait a minute. This judge has already pegged us. This judge said we must cooperate. So this judge might be more amenable to us resolving things with a lot of latitude. Or this judge might not want to get too involved in the medial things, so we may want to leave those things out and focus on the major issues. That's a clue. Or how about if the judge's ruling says something like, these issues are best to resolve at trial? Well, that's the opposite, right? Now you know the judge is going to be really, really indifferent to you dragging this case on. Because most judges in family court do not want to go to trial. So if you see something in the order that says, hey, these issues might be better addressed or suited for trial, you've just been tipped off that the judge really is not interested in any sort of protracted, the case dragging on just for the hell of it. The judge is gearing the case up for trial. Or how about the judge says something about the mother appeared agitated or dad seemed really cooperative? Those are some big clues, right? Yes. A lot of times that means, hey, mom, get your act together because I'm not going to be favorable from this point out. I've already pointed out that you are the problem. So, moms, if that's you, survivor or not, you'd better figure out a way. You better get some help. You better get some support. You better start working on regulating those emotions, finding a way to calm yourself down, finding something or someone to help you get organized, to help you focus, to help you prioritize, because the judge is just giving you a clue and or tip into what they see you as or view you as. That's really helpful and really important. How about, and this is very common, and this used to drive me crazy, and I see that judges still do this. How about if they put something in the order that said, parties are expected to comply with the current schedule? Oh, well, we know that. Right? That's what you're thinking. Judge, we know that. If that were the case, if the other party were doing that, we wouldn't be here. Right? So, again, the judge is like, listen, I'm not micromanaging your issues. I don't want to be bothered. I don't care what you do. Don't come back here with this crap. So what does that mean to you? What does that say to you? I don't know. For me, I'd probably say, you know what? Those little, late drop-offs or early pickups or missed event or missed phone calls or lack of cooperation with, providing information, I would probably be brave enough, bold enough to say, hey, you know what? Let me see if I can resolve this without going back to court. Let me see what other options are out there. Parent coordinator, maybe, mediator, something else, if a guardian item is one is involved, something else or someone else to help resolve this, because the judge just let me know that they're not going to micromanage our co-parenting relationship. How about when the judge said, and motion is granted, and that's it. They don't give anything else, no other reasoning, no other details, just motion is granted. Yeah, that happens a lot, especially with issues that the court just does not want to give too much emphasis on. Motion is granted. I don't like those orders myself. I never did. But when I was in private practice, I always paid attention to what the judge's reasoning was. So even by the time I got the order itself, I always paid attention. If I didn't, I went and got the transcript to give me some insight. So that's an option for you. If the judge's motion decision or ruling is short and it's not much information in there, then you may want to get the transcript. It's always helpful to look at the transcript. The transcripts are even much more helpful than the orders, actually. But the transcripts are usually not free. Some courts allow you to get them for free under the waiver process, but a lot of the transcribers are actually independent contractors. They don't have affiliations with the court. So some courts, you can bypass that by asking them for the CD or for the transcription for the audio itself and not the transcription, because the transcription is what's time consuming, and it's usually what they charge you more for, because it takes time to go through the audio to transcribe them. So, but if that's what you got and you really want to, decipher or analyze the order or the ruling, as I suggest, then yes, get a copy of the transcript. You can usually reach out to the court clerk and they will tell you, they will give you some options or the method and procedure by which to get a copy of the transcript. And if it's a hearing, if the judge's ruling is the result of an actual hearing, whether they call it that or not, anytime the judge reviews evidence and will ask questions from either party, it can usually be classified as a hearing. You should not allow the court to not do that without having someone in the courtroom transcribing or recording exactly what's happening. You should always, if you see that happening, you can ask the court, because you have the constitutional right, to have something or someone in the courtroom recording exactly what's happening. If you're being questioned or the other party is being questioned and the judge is looking at evidence that you submit or the other parties submit, whether it be by your attorneys or your pro se, then you have the right to ask that it be recorded. And then once it's recorded, they deny you, then you can, note your objection and you can maybe file a motion later to address the fact that the judge denied your quote unquote hearing on the record, to be recorded. That's what it means. So if that's the case, then you need to explore what the procedural process is in your jurisdiction for doing that. You can always Google court rules of procedure for the state of Georgia, and you can add the specific section, the specific issue that you want more detail on. So that specific issue would be a hearing not recorded in the courtroom or hearing not on the record or something like that, and find out what the procedure is for that happening and if there's any sort of recourse or redress for when the judge denies you. So that's how you should take every ruling, every decision, every order, and use it. And use it as a source of intel, of data, of information, of guidance, so that you know from this point forward how to actually use what the judge's mindset is, what the judge's preferences are, what the judge's perception of you is, what the judge's patterns are. You should absolutely do this from the first time. So especially when you are a survivor and you had a judge issue a ruling and you find that that ruling was not in your favor and you want to use that, the ruling, I mean, the intel from the ruling, the analytical data you got from the ruling to ensure that, those safety concerns you have, those abuse allegations, you'll know how to use them moving forward. Family court is not a place or space that's going to be endearing or compassionate or understanding or flexible because you're a survivor or because you've endured abuse in your relationship. It's just not the place. And there's so many reasons. There's so many different perspectives on it. There's so many different philosophies and beliefs. And I'm not going to get into whether or not they're all true or not true. But the reality is it's just not the place. It's not. I've been in family law for a decade. And I can assure you that when I talk to DV advocates, mental health professionals, who specialize in trauma, they all think that family court needs 1,000% revamping and redesigning and restructuring and maybe even abolishing because of the way it treats DV survivors, the way a lot of judges are apathetic or, completely lacking empathy when it comes to survivors. So if you find yourself in family court, though, because a lot of you can't avoid it, my point is, my belief is that you need to use what you know to be true about family court to your advantage. That you are not to say, woe is me, I give up. I'm not going to even waste my time fighting. I'm going to just roll over and just be re-traumatized over and over again. My perspective, my position is you take the information and you use it strategically moving forward. That means you take what you know to be true and you use it to plot out your every move from this point moving forward. So I hope this was helpful for some of you, or most of you, or all of you who are listening today. I really take it seriously, the impact or the collateral impact abuse has on families. I haven't trained in a while on DV, but I used to do it actually regularly. I haven't done it recently because I've just been so busy doing other things, but I recently did my first DV Awareness Month vendor exhibit, I guess that's what you call it, display this past weekend, and it was amazing. I got to talk to some survivors. I got to advocate. I got to inform. I got to enlighten. I got to educate. And so it was amazing. It was absolutely amazing. So I am on my mission to, get back out there and to do exactly that. But in the meantime, I'm going to leave with this thought. If you are dealing with anything, whether it be mental, emotional, financial abuse to actual physical abuse, you have to start with believing that you don't deserve any of it by anybody under any circumstance. You deserve way better. You do. But you have to believe that yourself. I can tell you this, anybody can tell you this over and over and over again. But until you start to believe it, you're going to continue to allow the system, not just the abuser, the system, to continue the abuse. And it will. So, on that note, I am going to end today's discussion. and hope that you are actually in a position to make a move, make decision, and change your circumstance. Until next time.
We want to thank you for joining us here at Self-Representing in Family Court, where we discuss all things strategy in family court. Join us next time. Until then, visit us at www.thedivorcesolutionist.com.